last speaker is Deniz Arbet Nejbir, and he's a Kurdish human rights activist and lawyer. He studied law at Ruskin College, Oxford, and the University of Warwick. He has also successfully completed, with distinction, an LLM in International and European Union Law at the Vrije University of Brussels. He has been working voluntarily in a variety of capacities under the umbrella of the Kurdish Federation in the UK over the last 13 years. He was the chair of the Kurdish Community Centre in London from 2003 to 2005. Additionally, he was the chair of the Kurdish Federation in the UK from 2009 to 2011, which lobbies to raise awareness of the rights of Kurds in Turkey. He has worked in London as a lawyer, specializing in asylum and immigration law. He's currently doing his PhD at Queen's University in Belfast. His research assesses the situation for the Kurdish minority right in Turkey and the Basque Country minority in Spain, with reference to the lesson that can be learned from Northern Ireland. On the basis of this assessment, his research will establish egalitarian and sustainable reforms for the issues concerning the Basques in Spain and the Kurds in Turkey. His paper is entitled The Use of the Kurdish Language Before the Public Authorities.
I'm going to talk about the use of Kurdish minority rights before the public administration in Turkey today. Why is language important? Because it's as a means of unity of the group and source of the self-identification. This is the reason why I'm looking at this aspect of language. Before starting my presentation, I would like to say that I'm going to start my presentation by focusing on 4 parts. First of all, I will look at the international and regional law with regard to right of language, and then I will look at the Turkish constitutions. After that, I'm going to look at the 2001 reforms in Turkey and critically evaluate them, and finally, I'm going to look at the 2012 and 2013 reforms and see whether it is symbolic or it is fundamental change. Okay, let's start. Okay, this is international regional law, which is related to try to use language, and there is a lot of case law with regard to that. There's Article 27 of International Covenant, Civil and Political Rights, International Covenants, Economic, Social and Cultural Rights, Article 1 of the Declaration on the Rights of Persons belonging to national or ethnic, religious and linguistic minorities, Article 10 of the Framework Convention of National Minorities, Article 10 European Charter of Minority or Regional Languages, Article 5 of UNESCO, and Copenhagen Criteria. Turkey had to sign Copenhagen Criteria in order to become part of the European Union. Now, the legal status of Turkey is based on denial of the existence of the Kurds on the basis of Lausanne Peace Treaty. The advocates of Republic of Turkey argue that Lausanne Peace Treaty defines minority on the basis of religion and omits linguistic and ethnic minorities. I will argue and challenge this interpretation on the basis of the fact of interpretation of the treaties under international law. When we interpreted the treaties under the international law, we have to look at the travaux preparatories of the treaties in order to find out the real meaning of that, what is happening. The Kurds were defined as the co-founders of the Lausanne Peace Treaty. I will argue that there is 3 main reasons for that. The first one is travaux preparatories of establishment of the Republic confirm this interpretation. If you look at the Erzurum and Sivas Congress, Amasya Circle-related, National Pact, and the Declaration of the Great Assembly, before establishment of the Great Assembly in Turkey, all of them define Kurds as the co-founders. Secondly, 1921 Constitution recognized Kurdish identity and granted them an autonomy. The 1921 Constitution didn't make any reference to Turks as a nation or proposed that citizens of Turkey were Turks. It simply stated that sovereignty is, without any condition and reservations, belongs to people. There is no reference to Turks there, or Turkish at all. Contrary to state argument, Article 39 of the Lausanne Peace Treaty expand protection to linguistic minorities, and this Article 39 or Article 39.5 made invisible by the state during the time. As we can see, Article 39.4 gives the right in private shepherd, whereas Article 39.5 gives a right to defense in oral trial defense. Conclusion, why the Kurds didn't want to be minority during the Northern Peace Treaty? Because the Kurdish deputies approved suggestion that they are co-founder of the state, and they believe that minority status would make them a subordinate group and therefore would undermine their co-founder position. They had a guarantee to be the co-founder of the state. And despite that, I will argue, in addition to being co-founder of the state, their linguistic rights were protected by the Northern Peace Treaty. Okay, then we have a denial of existence of Kurds. Shortly after the ratification of Northern Peace Treaty, the policy of Republic shifted from multiculturalism to homogenization, which is based on Turkifications. Several methods have been used by the state to achieve this. First, in the Kurdish region, the Turks were appointed to fill administrative posts. Personal names and the names of Kurdish places were changed to Turkish ones. The use of Kurdish language was prohibited, and the reference to the words Kurds and the Kurdistan were removed from the books and official documents and publications. And this is one of the main important points. Basically, a lot of my friends like Desmond will claim that this is genocide, cultural genocide, because what happened is the Kurdish children were taken from their family and they were sent forcibly to the boarding school in order to erase assimilation program, in order that they don't learn their language. And as a result of them, they accelerated the assimilation program. Now, in this part, in 1982 Constitution, I will look at the specific little bit of constitutions, and it's very important, Turkishness of Turkey. You can see that how the language becomes Turkishness, no people. Policy of identifying an essential principle of the state as the independence and integrity of the Turkish nation. We can see again Turkish nation there. The indivisibility of the country, the republic and democracy. And this phrase has been interpreted very widely, and that is what makes Turkey the biggest war prisoners for the writers, academics, and a lot of Kurdish human rights activists. Okay, the Article 3 of the 1982 Constitution states that the language of the Republic is Turkish, and Article 4 of the Constitution maintained that Article 3 needed to be amended or proposed to be amended. It's very important now. The recent reform is against the Constitution because
the first three articles.
Yeah. The recent reform basically is against the Constitution at the moment. And then we have Article 42, no language other than Turkish shall be taught as a mother tongue to Turkish citizens at any institutions of training or education. Now, let's compare it. Comparison of Constitution. We have 1921 Constitution, sorry about the 1-2 has gone. Sovereignty is without any condition, and reservation belongs to people. Yeah? And then we have Turkish instead, Turkish nations. Let's compare this with the European constitutions. Like, Italian constitution, there is no official language. In Irish constitution, there is 2 official languages in Ireland, Irish and English. In Spanish constitution, there is Catalan is the official Spanish language of the state. The other languages of the Spain will also be official in respective autonomous communities in accordance with their status. We can see when they give the right of official status, they don't undermine minority languages when they are in autonomous area. Now we are going to look at the reforms and see why the reform doesn't work. Okay, 3 main amendments made in the Constitution. In 2001, restriction on the use of any language prohibited by law in the expression and dissemination of thought was removed from Article 26 of the Constitution. The second one, in 2002, amendments in broadcasting law allows broadcasting in different languages and dialects. Turkish citizens traditionally used in their daily lives. You can see these amendments give right to broadcasting, but there is no name of Kurdish. There is no mention of Kurdish language despite the reform. And in 2003, the amendments make the public and private radio and private television to broadcast. In 2002, also there is an amendment which gives right of education in certain way, opening a private language courses, teaching different languages and dialects traditionally used by Turkish students in their daily lives. Again, we don't have anything there. It's important, and we are going to look at the nullifying legislation of reforms. Why the reform has been nullified? It's important to look at that. I think one of the main reasons why the reform is nullified, because each reform was implemented by the regulation which abolished any rights and freedoms that may have been provided by those reforms. And look at them. Let's look at them in practical terms. Okay. In those three amendments, the most important thing is this phrase, the indivisible integrity of the state with its territory and the nations. Yeah, it hasn't been changed. As the result of that, those wide interpretation of this phrase, now more than 76 only journalists are in prison in Turkey, apart from academics. And then, in 2007, after all those reforms, Anatolia Radio was initially suspended for 6 months and then suspended without limitation for playing a Kurdish song. We can see the Kurdish is not also banned in public authority, before the public authorities, but also in private use. Okay, there is also a lot of restriction on broadcasting. There is a direct state control over broadcast. They control their content. Teaching minority languages and children programs are prohibited. Broadcasters need a state authorization. Simultaneous and subsequent translation into Turkish for TV and radio programs are required. Okay, since 2008 in Turkey we have broadcasting in Kurdish. It's called Çanakkale again, and there is translation requirement is not applicable for that. There's discriminative, as we can see. And so far, 60 Kurdish words were banned to be used in state broadcasting channels so far. I was born in southeast of Turkey, and until I was 7, I couldn't speak Turkish. Honestly, when I watch this television, I don't understand anything in Kurdish. It's just like a combination of Arabic, Turkish, and they just impose basically Islamization on Kurds. Okay, let's look at some case law. What happened? When the reform was made, after the reform, the time when the constitutional reform was made, an action was brought by the prosecutor against 8 families for giving Kurdish names to their children on the basis that Kurdish names are not appropriate for national culture, moral values, and customs. The families were forced to rename their children with Turkish names. In Turkey, if you go to my school, the place which I was born, everybody has got 2 names. The name, the Kurdish one, and the name which at the school which we don't know until the teacher comes and tells us this is your name, basically. Okay. There is a case, Temel against Turkey, 2009. Students were suspended from the university for signing a petition to demand Kurdish education in university. Of course, they've been either expelled or suspended. Typical. They are suspended. This harsh reaction was found to be unreasonable and disproportionate by European Court of Human Rights, despite Turkey derogated Article 2(1) right to education. Okay, there is a lot of cases against mayors of Kurdish mayors, and the reason for that is like because they use either X, Q, W, which is done in the Turkish alphabet. Now, for example, the Kurdish mayor of Diyarbakir commented that there are 30 lawsuits filed against me, all which are related to use of Kurdish language in 2007. Okay, the broadcasting is allowed in Turkey, and we have like 24 hours Kurdish channel. But when the Kurdish leader, the party leader, DTP leader Ahmet Türk was speaking to celebrate International Mother Day, the broadcasting was cut by the state. Okay. In December 2010, the Sur municipality in Diyarbakir, they put it downstairs and writing on it that it is like belong to them in Kurdish, and that said it's violence, and therefore they have to take them back. Now we have violation of international law here. I just mentioned the Tamil case, and on February 2010, 3 students were sentenced 6 years and 3 months imprisonment sentence for roles in boycott of classes and read out a public statement demanding mother tongue education, and they were sentenced to 6 months for that. This is contrary to the Tamil and Turkey judgment, which I just mentioned. I just want to compare two cases, which is, I think, is very important. The Sur municipalities decided to provide multilingual municipal services on the grounds that 72% of people who live in this district speak Kurdish in their daily life, whereas 24 of them speak Turkish. Consequences, the dismissal of the mayor of the district and the dissolution of the council. Now, in Diyarbakir, Namibia, this is international case decided by Human Rights Committee, the civil servants were instructed not to reply to the claimant who was a member of minority. It was argued that there is no discrimination against the use of Afrikaans by public authorities since all the languages apart from English, which is official language, are prohibited. Human Rights Committee held that the justification is given on the basis of an official language policy to prohibit the use of minority language by public authorities is not sufficient and reasonable. This is very clear that is violation of international law. Okay, ongoing denial of Kurdish language. In November 2010, Diyarbakir 6th Criminal Court is called the Kurdish unknown language. Then, one of them, they called supposed to be Kurdish or so-called Kurdish. And we have the Deputy Prime Minister, who is very clever. He said Kurdish is not language of civilization. I don't know where does he get such a fact. Yeah. And we have recent reforms, law, again, 6287 offered and selective courses in living languages and dialects for 2 hours a week in public schools, only in secondary school level. Yeah. It can only be taken in secondary school, not in primary, not in high school. No graduate Kurdish language department is existed in Turkey so far. It has master program. It just exists in one university. And only in contrast to private school, there is no requirement of being graduated from the Kurdology department. Teachers are selected from people who are graduated from the Turkish language and literature department on the basis of the candidates. There is also amendment in the political parties, and you can see the only amendment, which is we can't see here, but the only amendment is here. Instead of can't use it, they say that can use Turkish and dialects, and use a language which people of region will understand. Yeah, but it didn't touch the like if you look at the Article 2, protection, development, and spread of other languages and cultures other than Turkish is prohibited. Yeah, as the result of that, despite this reform, prosecution always finds something in the constitutions to bring a case on the basis of the languages. Yeah, after that decision, we have Faik Kaplan case, who was in prison for 6 months distributing Kurdish postcards to honor Kurdish New Year, just like 2 months ago. Then we have Sewahir Bayındır and Hamid Geyrani case. On one hand, the facts are the same. One court says it shouldn't be in prison, the other court says no, it should be. There is inconsistency about the judgment and judiciary as well. Now, and the Kurdish language is in this trial. It's very important. More than 10,000 Kurdish political prisoners, they put their body to hunger strike in order for Kurdish to be allowed. And as a result of that, there was a huge pressure from Turkey and internationally, which makes Turkey to take certain steps to change little bit law to allow detainees to speak their mother tongue in the court. Yeah, a detainee may make his oral defense in a language that more confident to express himself. Okay? The legislation gives wide discretionary to the judge. If the judge believes that the defendant choice of use would prolong the time of hearing, the judge can dismiss the request defense in mother tongue. Interrogation, it people are not allowed to defend themselves in interrogation and investigation process, detention in police station, and do not provide a right to written submission in mother tongue to the court or any other prosecutor or police. Witness and third party of the hearing can't benefit from this right. It is discriminative, according to my point of view. Detainee who can't pay enumeration of interpreter can't benefit from this right. Like if someone is German, they will bring free interpreter for them in the court, but when it's Kurdish, it's not. And I will say something in Turkish first. Türkçe konuş, çok konuş. This is an expression which is used in Turkey. They said you can speak Turkish as much as you want as long as you speak Turkish. And this is as long as you have money, you can defend yourself in the court. This is against the concept of not guilty unless it is proved. Detainee has to pay for accusation that he is not convicted for it yet. In the criminal law, there is no concept of payment for defense. It's also against Article 6 of European Court of Human Rights. I'm just going to look at the case law because I don't have time. In Kamasinki against Austria, European Court of Human Rights decided that assistance of free interpreter should not only be provided for oral hearing at the trial, but also to documentary material and the pre-trial proceedings. Basically, the case simply shows that Turkey is breach of by not assisting free interpreter, is breaching its international obligation, plus not accepting to be free oral things. Okay. After that, again, after all those legislation, demands of political prisoners to defend Kurdish was not to defend themselves in Kurdish was not allowed by the court. Just like a month ago, the Istanbul Heavy Panel dismissed their request. Also in March, Diyarbakır Heavy Panel also dismissed their request to defend themselves, despite they are willing to pay for it. Okay, why? Reason for failure of the reform. Reforms are so symbolic. Many articles of Constitution still ban the use of Kurdish, like general provision of the Constitution of Turkish Republic, Article 3, 4, and 14. Number 5237, imprisonment misfiances. Number 805, law on obligatory use of Turkish in commercial institutions. Article 2 of law number 1355 on adoption of Turkish status and the application which regulates criminal sanction in Article 222 of Turkish criminal law. This can be imprisoned for 6 months and 3 years. That depends which one you are using and which one the prosecutor bring action against you. And then I will conclude. I will conclude that reforms implicitly provided limited and conditional rights to Kurds without naming them. Despite the reforms are positive steps, reforms are symbolic and far from being the fundamental constitutional change. This tendency to stitch up of situation for a short period of time should be stopped by the state. For general and permanent solution, there is a need for a new civil and democratic constitution, which is the Professor Tapiokus is going to give detailed analysis of that. Thank you very much.